Testing sound. Sound test.
Good afternoon. My name
Sound check. Testing sound. Sound check. 1, 2, 3. Sound check.
is Jerry Dyke. I'm the chairperson of the
Good afternoon, everyone. We'll start just in a minute. Good afternoon, everyone. Just before we start, I will just remind the speakers and the audience for the questions to please switch off your microphones once you're done speaking for the for the video. So we're here today for a side event sponsored by COGEP and organized by the International Center for Justice and Human Rights, the Al-Karama Foundation, and ICF UAE to discuss the human rights situations in the UAE and in the context of the Universal Periodic Review that was held in January of this year. We held a side event on 14 March during the last session of the Human Rights Council, in which we discussed already the UPR recommendations that were formulated, and among the issues we highlighted were the lack of implementations of the recommendations issued already 5 years ago in 2013 during the UPR. And among the issues raised by the speakers were the attacks against human rights defenders, the practice of torture, the lack of cooperation with the UN human rights mechanisms, with the UAE having appeared in the last 5 reprisals report issued by the UN Secretary General. So last week, the outcome of the Universal Periodic Review of the UAE was adopted. The UAE accepted 132 recommendations and noted 98. That's a rate of 57%, which is quite low, but still stable in comparison to the last UPR of 2013. I will let the speakers later discuss the UPR recommendations, but I just wanted to highlight a few recommendations that were only noted by the authorities, among which the call to ratify the ICCPR, the call to issue a standing invitations to special procedures, to stop and investigate acts of torture, take measures to ensure the right to freedom of expression, amend the cybercrime law, amend the anti-terrorism law, release political prisoners, take measures to ensure that human rights defenders can carry out their work in a safe environment. All of these recommendations were not accepted by the UAE, and we believe that it also shows a lack of commitment from the authorities to really abide by human rights principles. I have with me today Ms. Safwa Aissa, the Executive Director of ICGHR. We will then hear a presentation by Mr. Dyke from the Rights Realization Center, but there will be a video. Then I have on my left Ms. Julia Legner, who is Regional Legal Officer for the Gulf at the Al-Karama Foundation. Mr. Rodney Dixon, who is a UK barrister and Queen's Counsel in London and The Hague. And then here on my right, Mr. Joe Odell, Campaigns Manager of ICF UAE. So I will open this by giving the floor to Ms. Aissa.
I think it works, okay. Thank you, Ines, and thank you for all our colleagues for their presence today, and for COGEP to helping us to and collaborating with us to organize this conference. So, ladies and gentlemen, in this presentation, I would like to recall the issues raised by the International Center for Justice and Human Rights during the Universal Periodic Review, in the pre-session especially. So I would also like to draw attention to those recommendations the United Arab Emirates failed to accept in its final report, as well as the worsening condition of human rights in the country. Drawn also from recent cases, which makes the acceptance of these recommendations all the more important. First of all, let's say that the authorities' reaction to the recommendations leaves us perplexed about the implementations process. It is paradoxical for us to note that a number of general recommendations accepted on the one hand, and the reserve shown for the specific and targeted recommendations on the other hand. So this raises questions about the seriousness of the government to take concrete steps to improve the human rights situation as promised by the state and the delegation in the UPR main session. So, and while we welcome the UAE acceptance of 132 recommendations made by the third UPR, their reservation to certain key recommendations continue to worry us. to name especially the ratification of the International Covenant on Civil and Political Rights and other core international human rights conventions. Also recommendations related to the investigation of all allegations of torture, prohibition of the practice of secret detention, release of prisoners of conscience, etc. During the pre-session of the PR29, alongside other NGOs, we highlighted issues concerning attacks on human rights defenders especially, and the condition of detention and reprisals against families. These issues continue to be pertinent today. With regards to human rights defenders, for example, paradoxically, the state accepted the recommendations of France, Norway, and Latvia to take steps and measures to protect human rights defenders, but do not support the recommendations of Belgium, Italy, and Austria to ensure a safe environment for human rights defenders. The current situation leads us to consider them still under threat as the authorities continue to arrest and unfairly sentence human rights defenders. We recall that few months after the main UPR session, Mr. Ahmed Mansour, a prominent human rights defender, was heavily sentenced to 10 years imprisonment on 29th of May 2018 for his human rights activities on social media. Despite numerous appeals by human rights organizations and the special procedures condemnation of his arrest, he is still held in solitary confinement with limited visits. With the arrest of Ahmed Mansour, the United Arab Emirates authorities have emptied civil society of all free voices, and the crackdown on human rights defenders, whether male or female, continue unabated in the UAE, requiring urgent attention by the Human Rights Council. Additionally, the UAE continues to use counter-terrorism laws to punish human rights defenders. The case of Dr. Nasser Ben Gaith is relevant. He was sentenced under the Federal Law number 7 of 2014 on combating terrorism offenses to 10 years in prison for tweeting. Also, and although we welcome the acceptance of a recommendation concerning rejection of evidence obtained by torture, it is the number of recommendation 141, 134, we remain worried and we regret that the state simply noted all the recommendations related to the prevention and investigation of torture cases. In this regard, we continue to receive bad news about conditions of detention in UAE prisons. We received cases of torture and ill treatment of women in UAE prisons, which become increasingly popular. Our organization received recordings from the prisoners of conscience Amin al-Abdouli and Mariam al-Balushi, and letters from Ali Abdel Noor family where they testify about their experience of torture in Al-Wathba prison. They speak about their suffering of physical and psychological abuse. They have been forced into, for example, they have been forced into stress positions, beaten, interrogated, deprived of medical facilities and basic sanitation and hygienic, and horribly tortured. We recall that the authorities of the UAE are refusing to release Mrs. Ali Abdel Noor despite her confirmed final phase cancer. This is in disregard of the UAE federal law or regulating penal institution, which states that the Attorney General must release the detainee whose health and life are threatened by disease. On the other hand, we welcome that the state has accepted the recommendations about the establishment of a national human rights institution. We are waiting the creation of this institution this year, 2018, as promised by the delegation to improve the role of the civil society, especially in the field of human rights. We welcome also the decision to send their report on torture to the UN CAT a few days ago. This report opens the door to many victims to advocate their cases before the committee. Hence, as follow-up to the adoption of the UAE report, we believe that the country still needs to accept key recommendations if the human rights situation in the country is to improve. As to the accepted recommendations, we hope that the United Arab Emirates will respect its commitments and ensure the effective implementation of these recommendations. On our side, from our side as an NGO, we will continue to monitor and follow up the situation in light of the UPR recommendations, and we call upon the UAE government to respect their commitments. Thank you for your attention.
We'll now be watching a video by Mr. Dyke from the Rights Realization Center.
Rights Realization Center. It's a charity based in London. I want to thank the organizers today, COGEP, ICJHR, Al-Karama, ICF UAE, for the opportunity that they've given me to reflect very, very briefly on the United Arab Emirates reactions, its conclusions to the UPR, the Universal Periodic Review, of this current session. This round has been bookended by the 2013 mass trial and conviction following an unfair trial of over 60 individuals in relation to an alleged attempt to overthrow the state. Of course, in the course of the trial, it never became clear in that process what they were exactly trying to do, and worse, it appeared more that a number of them were in fact human rights defenders. It's bookended by that event and by the May 2018 conviction after a year of, in effect, incommunicado detention, solitary confinement, and so on, to the extent that one knows, of Ahmed Mansour, a laureate of the well-known Martin Ennals Award, who also has been convicted to 10 years imprisonment. Those two set the scene, I feel, for a human rights situation in the UAE, and one in which is characterized in many respects by a series of assertions. You know, the government has asserted that in the 2013 trial, the UAE 97 it's often called, that they were criminals, that they were up to no good, that they were trying to overthrow the state, and that what Ahmed Mansour was trying to do was to really actively defame the state and to rip asunder, you know, elements of its moral fabric and its social fabric and so on. And these assertions that the government has adhered to the law, that on the contrary, these other individuals, Mohammed al-Rukn, Mohammed al-Mansouri, Ahmed Mansour, have violated laws and legislation, are precisely that. They're assertions that serve to obfuscate and to deceive a world which otherwise doesn't really know any better. It doesn't know any better precisely because there's such a weak environment for freedom of expression, freedom of press, freedom of association, and so on. So coming full circle, that brings me to the UPR. And okay, look, the UAE on this occasion said that it has accepted 132 of the 230 recommendations, and that it takes note or will study a further 98. But taking note in itself is a deception. If you don't agree to a particular point, if you don't accept a particular point, then by saying we'll study it or we'll take note of it, it's in effect a rejection. Look, not all of what the UAE has done, is doing in respect to the UPR and its conduct in the country is bad. It did accept a swathe of general comments relating to human trafficking and migrant workers, very general things. And that characteristic, the characteristic of accepting generalities accepting generalities but rejecting specificities, it runs throughout the document. I guess what we deplore, what ICJHR, Al-Karama, my colleagues in ICF UAE and so on, I guess what we deploy is this obfuscation or the assertion that the UAE engages with UN mechanisms, because precisely it rejects specific recommendations in respect to inviting the Special Rapporteur and human rights defenders, or to not issue a standing invitation to thematic mechanism. It asserts engagement, but rejects all of the recommendations in respect to acceding to treaty bodies, as if it really doesn't want independent scrutiny from these bodies it can't control. I just want to discuss HRDs, human rights defenders, just for 1 minute, and that will be the focus of my short intervention today. It did accept, again, a general recommendations, 141.127, made by France in respect to human rights defenders, but it rejected very specific ones about taking specific measures to protect them. And in respect to this nexus of administration of justice and human rights defenders, sure, again, they accepted generalities, but again, thinking of Mohammed al-Rukn, of Ahmed Mansour, Mohammed al-Mansouri, and indeed others, they rejected, for example, a Botswanan recommendation to limit pretrial detention, or a Chilean recommendation to inform loved ones of where people are held. Look, can it get better? Can this UPR process itself lead to a betterment of the human rights situation in the UAE? Well, of course, we hope so. The government in the UPR, again, with respect to these generalities, it asserted that it accepts protection and upholding freedom of expression, and it accepted an amendment to the press and publications law. Again, sadly, it rejected specific Estonian and Canadian recommendations in that same regard. So there's no immediate prospect that the usage of Twitter or online expression will get any better. But taking a step back, and this is how I suppose I'll conclude, there is no effective accountability mechanism in the UAE. The Federal National Council is weak. They may exercise unprecedented authority and power, in part because of the conflict in Yemen. Its global reach, the UAE government's global reach now, is really as great as it's ever been, the greatest. But when I asked around, when I speak to special rapporteur teams and country missions, its credibility as a rights respecting country is falling. It's in free fall. People put up with the UAE. Countries put up with the UAE. They adhere to its objectives and its needs because of its economic power. So if we can boil it all down, if we could just sort of distill the essence of the UPR into a couple different things, I guess I would make a plea to Anwar Gargash, Dr. Gargash. Just accede to one international covenant, the ICCPR, the International Covenant on Civil and Political Rights. Just have one special rapporteur visit, human rights defenders, for example. The special rapporteur in the independence of judges and lawyers visited a few years ago. It led to one significant change. It's not going to overthrow the government, Dr. Gargash, or Abdullah bin Zayed, Sheikh Mohammed bin Zayed. It's not going to change things. In the worst case scenario, it will get better. So I leave you with that plea, as you maybe take this through to the discussion, is if we had to boil it down to one practical thing that the authorities could do, is one relevant treaty body, accede to it, get one special rapporteur into the country. Thank you very much again for this opportunity. I hope you have a good discussion today. Sorry I can't be with you.
And now I'll give the floor to Julia Legner from the Al-Karama Foundation.
Thank you very much. Today I would like to share some observations on the UPR outcome. As a member of an NGO that followed the entire process of the UPR of the United Arab Emirates, that means that we submitted an alternative report. We also participated in the pre-session briefing. we lobbied UN member states, and then we were present at the review and at the outcome, and we're now going to give some observations on the outcome, but even just a first observation on the process itself. At the pre-session briefing, which is NGOs or civil society briefing UN member states ahead of the review, there were no local civil society actors, and usually priority is given to anyone working on human rights from within the country. Unfortunately, that was not possible, as civil society space is really non-existent for critical human rights organizations or activists in the country itself. Now to come to the outcome, well, we've seen that only 85 recommendations were noted, and there I would like to echo the statement made by Mr. Dyke from the Rights Realization Center, that noted means taking note, but really there's no willingness to address this or to really implement these recommendations, and therefore I will take a note also as a rejection. Now I would like to also say that I share the comments, or share the view expressed by colleagues that what we see again is that a lot of general recommendations were accepted by the UAE, as opposed to specific recommendations to, for example, amend legislation or to let a special reporter enter the country, which in all fairness maybe is also a common pattern of countries with a rather poor human rights record, as basically it is very difficult to prove 4 or 5 years from now on whether a recommendation was indeed implemented or not, if it's phrased in very, very vague terms. First of all, I would like to say that, of course, we regret to see that there's no willingness to ratify some of the most fundamental basic human rights instruments, foremost the International Covenant on Civil and Political Rights, but also the International Covenant on Economic, Social and Cultural Rights, the International Convention on the Protection of All Persons from Enforced Disappearance, the Rome Statute, the Optional Protocol on the Convention Against Torture, the 1954 Convention relating to the status of statelessness persons, as well as the 1961 Convention on the Reduction of Statelessness, as well as the ILO Convention 189 on the protection of domestic workers. So altogether, that really shows an unwillingness to comply with the provisions in these most fundamental human rights instruments. In general, to the UPR outcome, I would say it was marked by controversies and contradictions. The UAE, for example, accepted a recommendation by Pakistan to strengthen its cooperation with the UN human rights mechanisms, and a Saudi recommendation to strengthen cooperation with treaty bodies, including the submission of periodic reports. Well, at this point, I would like to say, as already mentioned by Safwa, that indeed the UAE have now submitted their initial, nearly 5-year overdue initial state report to the Committee Against Torture, which is a great opportunity, or will be a great opportunity, for civil society to also submit their reports and testimonies to the Committee Against Torture, which will most likely be reviewing the report by the UAE and the UAE in the first half of next year. So coming back to the cooperation with the UN human rights mechanisms. The UAE has also accepted a recommendation by Germany to cooperate with the UN human rights mechanisms, including by responding positively to visit requests by the special procedures mandate holders, but at the same time it rejected all recommendations made to issue standing invitations to the special procedures. And it also rejected to accept the pending visit request by the Special Reporter on Human Rights Defenders. That is quite problematic, as we can see, the UAE has 8 pending invitations by the Special Procedures mandate holders. If indeed it is willing to accept visits, then I would suggest it starts by the 8 pending requests, some dating as far back as 2005. The most recent request for a country visit was addressed by the Special Reporter on the promotion and protection of human rights while countering terrorism in August 2017. Others were made by the Working Group on Arbitrary Detention, the Special Rapporteur on Freedom of Expression, the Special Rapporteur on Torture, and the Special Rapporteur on Human Rights Defenders. Also, if the UAE is so willing to cooperate with the UN human rights mechanisms, I suggest that it implements all the opinions issued by the Working Group on Arbitrary Detention, which declared the detention of over 85 individuals as arbitrary for making use of their fundamental rights and freedoms, and asked for their immediate release. And that is since 2013 alone, so just since the last UPR circle, 85 individuals have been declared arbitrary by a UN body. That would be a good starting point, for example. Moving on to the unfortunately still very present practice of torture in the UAE. The UAE said no, or only noted, the recommendation 109 by Qatar to stop and investigate all acts of torture and cruel treatment and to prosecute those responsible for its order and perpetration. It also only noted the recommendation to prohibit the practice of secret detention and institute safeguards against torture and other ill treatment. Isn't that a bit strange that a country that has now submitted its report to the Convention Against Torture, to the Committee Against Torture, is not accepting very basic recommendations to investigate acts of torture, to prevent torture, and to prosecute its perpetrators? To me, that leaves a question mark and doesn't really show real commitment of the state party to eradicate this practice. Moving on to another great concern, freedom of expression. The UAE accepted recommendations 112 and 113 to protect freedom of expression and freedom of association, and to take further steps to ensure freedom of expression by strengthening the knowledge and capacity of the state apparatus. Well, it did not accept, however, any recommendation to review or amend the legal framework preventing freedom of expression. The UAE also clearly rejected the recommendation issued by Sweden to amend the cybercrime law, the anti-terrorism law, and provisions of the penal code restricting freedom of expression in order to bring them into conformity with international standards. So again, we see these general recommendations where there is somewhat limited willingness to address the issues, but then as soon as it gets a bit specific, there's nothing but rejection, which is difficult. I mean, if you're not willing, if you on the one hand say you're willing to protect freedom of expression, but not willing to amend or revise the laws that still criminalize freedom of expression, then we are at odds, and it doesn't look like we're going to get anywhere in the protection of freedom of expression at the end of the day. So altogether, we do remain concerned about the human rights situation in the UAE, specifically the extremely restrictive legal arsenal to crack down on freedom of peaceful assembly, association, and freedom of expression. The laws we're talking about here are the press and publication law, the cybercrime law, the law on combating terrorist offenses, and the new amendments to the penal code. We also remain concerned about the arbitrary detention of anyone critical to the UAE authorities and all the prisoners of conscience, including members of the UAE 94, Ahmed Mansour, Osama Najjar, Nasser bin Ghaith, Taysir Salman, and many others. And lastly, of course, the systematic practice of torture, which to this day is used both as a form of punishment and as a mean to extract confessions, which are later used to incriminate individuals in court proceedings, and for which we also do not really see any investigation or prosecution of perpetrators of torture. So where does that leave us? Looking into the future, while we're not very hopeful that the UAE will seriously work on improving their human rights record, we will use the review of the UN Committee Against Torture, as an opportunity to assist and encourage the UAE to develop a comprehensive legal framework to prevent torture, eradicate the practice, and prosecute all its perpetrators. And moreover, which I think was not mentioned so far, the UAE has actually accepted a lot of recommendations as to the establishment of an independent national human rights institution. So I can say we look forward to the official establishment of this institution, and we will try to cooperate with it in the hope that it will be independent of the authorities. Thank you.
Thank you very much, Julia. We'll now be hearing some comments from Mr. Rodney Dixon. You have the floor.
Thank you. Good afternoon. It's delightful to be here able to participate in this discussion today, but in a very disappointing context worldwide, where we lack, it seems, international leadership on very important issues relating to detention and torture, which are one of the main topics that we are discussing today. We've seen recently the President of the US saying that torture is acceptable in certain situations, including waterboarding. We've witnessed the new deal with North Korea, where there's been much more focus on which hotel people were staying at compared to the situation in jails and those who've been exposed to torture over decades. Also, I'm sure you've all been watching the World Cup with Russia basking in the glory of that event, despite its flawed human rights record and the activities that it's been up to in countries like Georgia, Ukraine, and even in the UK as well. And it's equally disappointing that in that wider context, and perhaps there is no leadership to show the way for countries like the UAE, that, as has been emphasized, the key recommendations in respect of torture and investigating those incidents and allegations haven't been grasped and taken on. I'm going to talk briefly today about some of the cases I've been involved in as a practitioner, because that's where I come at it from. I get approached by victims of torture in many different countries, not only the UAE, to take up their cases and to seek remedies. And I emphasize that there are many countries involved because, as I always stress, this is not about singling out one country, the UAE. It's about looking at these practices across the board and trying to show how there have been positive precedents for change. It's not just a question of condemning, it's about how we can find constructive solutions. That's what we should be focusing on. Talking from my own country in the United Kingdom, it has had a checkered past with allegations of torture, going back to the conflict in Ireland, where the UK government was in fact sued by Ireland in the European Court of Human Rights. And the UK government and national authorities and police forces and armed forces have had to address that issue very directly, including in relation to allegations from Iraq, from Afghanistan. There have been many inquiries, many investigations. A special unit has even been set up, running into the millions of pounds to investigate these kinds of allegations. And it shows that countries around the world face these problems, and yet they come up with ways of looking to clean up their acts, because we just can't have a situation where torture is routine and is used as a means of suppressing opposition, whether it's thought to be opposition or not, or of implementing government policies. Any government needs to look at ensuring that it has a clean bill of health. I mean, that's what we should be striving for. Certainly, the UK authorities have sought to do that. In the US as well, you would have heard and read, I'm sure, the very long Senate report on torture, allegations, very serious allegations against US forces in countries like Iraq and Afghanistan. The important thing is it's come out. People are doing something about it, and it shows as a precedent to countries, including the UAE, that positive steps can be taken, and that's the standard that we should all be striving for. It is always difficult to reach the highest levels and achieve these things, but we've got to at least be trying with the right mindset. And in many cases, it then does work. It's not possible, I accept, to charge and prosecute everyone, including those to the highest levels in government instantaneously. From my work with many governments over the years, I've noted that governments don't like to investigate themselves, put their own officials on trial. That's not something specific to the UAE. But many governments have taken steps over time to set up inquiries, to make sure that people are removed, to change their practices so that it doesn't happen at least again, and also to prosecute people where possible. The cases that I'm involved in relation to the UAE involve victims of alleged torture where they haven't been able to get remedies within the domestic system in the UAE, and therefore they've had to use mechanisms of universal jurisdiction outside of the UAE to try and find remedies. And that for me highlights exactly what the recommendations have put the finger on, is that where a country is refusing to take on these measures itself and take the steps like I've shown other countries have done, then victims have no choice but to go abroad. In my case, representing 3 Qatari nationals who have come to the United Kingdom to ask the UK police to investigate allegations of torture because they haven't been looked at internally. There are other cases as well that raise the same problems. And these are difficult cases, both for the national authorities in the UK because of the international relations, and also for the UAE and the embarrassment factor. And it could all be avoided if the national authorities there took on the responsibility of having proper inquiries themselves into what happened. Where that doesn't happen, we have to look at these forms of universal jurisdiction. And in the UK, that's exactly what the police are doing. If alleged perpetrators travel to the UK, they can be stopped, they can be interviewed. We are at the moment, I'm not going to go into a lot of the detail because it's all a case that's ongoing, but are in the process of building the evidence in those cases so that there could be full investigations and prosecutions, so that the victims feel that at least there's a record of what happened, and hopefully there can be justice thereafter as well. If nothing is done in the UAE, well then other countries like the United Kingdom or other places where there's universal jurisdiction, there are a number of countries that have these systems in place, will have to step up to the plate. We've seen a case recently involving a Nepalese official in the United Kingdom who was captured and prosecuted, in fact acquitted in the end, but it shows that you have to observe people's rights to a fair trial. It doesn't mean just because they are accused that they're necessarily going to be convicted. There has to be a proper process, but that sets the right example again for countries like the UAE as to what they should be doing internally. There have been other universal jurisdiction prosecutions in relation to conflicts in Syria and Yemen. There are some in Germany now. And this shows the way. If the permanent international criminal court can't be used because countries are just not signing up, then those countries that do observe human rights to the highest levels and are trying to promote it have to look at closing the impunity gap through universal jurisdiction. Even if it's difficult to take on these cases, because they are broad, they are very costly, there has to be a commitment to take them forward. And so far, there is. There are often, as exists in these situations, political barriers, economic barriers, but that shouldn't be a reason why countries don't fulfill their commitment. And if the recommendations that are coming out are not going to be adopted, well, then other partner countries have to take on those obligations themselves. But I stress once again, this is something that the national authorities in the UAE could resolve very swiftly. Not an easy process, I know, but they could resolve it by taking on these steps themselves, getting in the necessary expertise, revising the law to allow these investigations to take place in a credible way internally, and in that way to set the benchmark for preventing future activities. It's very much linked, of course, to what has been said around freedom of expression. A lot of these measures are taken because of the fears of what views are being expressed. I've seen this in many countries. It's usually a resort of those persons who are most fearful of what might be said against them to silence through these measures. And it's no use just saying, yes, we support the principle without having the laws in place to allow expression to take place. Of course, in a peaceful and non-violent way. And of course, it allows also those who might oppose those views being expressed to continue doing that vigorously. It doesn't mean that the government then has to keep quiet. They can conduct a very robust campaign of criticizing their opponents, but they don't have to torture them because they have different views. They should win their ideas and the policies that they propagate through public opinion in the open marketplace, not by doing it in underhand means. So my message would be, coming from the cases that I've been involved in and future cases that are being brought, is that the recommendations that have not been taken on, the key ones in many respects for certainly the clients and others who I represent, should be, and there's always the opportunity to do it, should be reconsidered by the UAE authorities. They can draw on the UN procedures and expertise as much as is needed, and that steps should be taken to use the sovereign powers of the state concerned, not to let outside interference take place through the ICC or through universal jurisdiction. You have, in those countries, and in the UAE in particular, the power to do it yourself. And it should be embraced as opposed to being pushed away as seen as something that won't succeed. There are many examples of how it has worked in other countries, and I believe that it can do so again. One other aspect I just wish to mention before concluding is what was touched on, confessions. We had a big problem with this in the UK as well, with the IRA cases, where confessions would just be taken out of people and used to prosecute people who were so-called terrorists. That term has been used in many different contexts over the years. I'm originally from South Africa, and I remember how everyone who opposed apartheid was accused of being a terrorist in the 1970s and 1980s. And yet now, those people who were supposedly terrorists have been lauded. They either in government running the country, or people like Nelson Mandela have statues in Parliament Square. And it's amazing how the rhetoric has changed. Those people who were once terrorists have had to be embraced as peacemakers. The same can happen in places like the UAE. Of course, real terrorists, people who use violence to kill civilians for no reason, should be prosecuted. There should be no excuse, and they should receive the highest sentences. But people who are not terrorists should not be labeled as that simply because they oppose apartheid or they oppose freedom of expression prohibitions. So important not to use those kind of labels to extract confessions. We had this problem in the UK, as I say. It brought out many cases where police officers were exposed. The same thing can happen in the UAE. Stop using confessions as a way of prosecuting people. If they've done wrong things, just gather the evidence and prosecute them. Don't use these shortcuts. In my cases, all of my clients were put in the situation where they had to confess because they thought they were going to be released. And then those confessions were used against them, and even in some cases aired on television later to try and humiliate them even further and break down their reputations. It's a very dangerous and damning way of proceeding, using those kinds of shortcuts to prove cases. And it's proved each and every time in other countries, including the UK, you get tripped up, you get caught out, and then you have to reform. So don't even start in the first place, or if you're in that situation, change it as quickly as possible. Confessions is a very important aspect of any judicial system that has to be eradicated. I just want to end a quote which I often cite on torture, and I always think it's important that you've got to have some Sartre in your repertoire as well. But what Jean-Paul Sartre said about torture is that it is a senseless violence born in fear, and we would almost be too lucky if these crimes were the work of savages. The truth is that torture makes torturers. And that's why I've been emphasizing throughout my talk today that you've got to make the recommendations a reality, turn them into a living reality. Otherwise, all that we're going to do is create more torturers, more situations which will ultimately be used against us. If you are torturing today, you will be in that situation where you are tortured in the future because you've set the standard. So stop torture, and then we will not allow the process to gain legs. It can only be done through our actions, human actions. It has been done before, it can be done again. Thank you.
Thank you very much, Mr. Dixon. I'll now give the floor to Joe Odell for comment.
Hiya. Hi. So the International Campaign for Freedom in the UAE is a not-for-profit, independent, non-partisan human rights campaign set up to advance and protect human rights in the UAE. And this statement will highlight what was raised during our participation in the pre-session on 13th of December 2017 and reflect upon what was raised during the 29th UPR. During the pre-session, amongst other civil society organisations, ICF UAE documented the deterioration of fundamental human rights in the country, and our statement in particular focused on cases of arbitrary detentions and enforced disappearances. So I would like to remind those present that between 2013 and the beginning of 2017, 100 detentions were declared arbitrary by the Working Group on Arbitrary Detention, and during the same period, 37 actions were sent by the Working Group on enforced disappearances, of which 5 are still outstanding. There have been countless more disappearances and arbitrary arrests documented by human rights groups. In the previous UPR in 2013, there were no specific recommendations given regarding arbitrary detentions or enforced disappearances. However, several states, including France, Austria, Switzerland and Finland, recommended ratification of the International Covenant for Civil and Political Rights, which forbids these practices. The UAE did not accept any recommendations regarding the ICCPR. However, as a member of the Human Rights Council and a signatory to the Universal Declaration of Human Rights in the UAE has agreed to abide by Article 9, which declares these practices contrary to international law. Nevertheless, there have been no visible efforts to improve upon these points. Arbitrary detentions and enforced disappearances have continued unabated in these past years. In response to this, during the 29th UPR, 19 states such as Germany, Australia, Slovakia and Japan recommended ratification of the ICCPR, and a handful of states recommended ratification of the International Convention for the Protection of All Persons from Enforced Disappearances. I would like to acknowledge the significance that so many states are recommending such an important treaty, but without these recommendations being accepted and acted upon, the UAE can continue unchecked to act essentially with impunity. So in order to illustrate the necessity of pressuring the UAE to accept recommendations to ratify treaties which prohibit the practices of arbitrary detention and enforced disappearances, I will illustrate a selection of cases that have occurred since the last UPR in December 2017. And obviously a case which has gained notable publicity in the last few months has been the alleged disappearance of Sheikha Latifa bin Rashid Al Maktoum, an Emirati princess and member of the Dubai royal family, who is the daughter of the UAE's Prime Minister and ruler of Dubai, Mohammed bin Rashid Al Maktoum. In February of this year, Latifa attempted to escape the UAE in order to start a new life in the United States of America. However, according to the UK-based NGO detained in Dubai, this was thwarted after the boat she was trying to escape on was allegedly raided by Indian and Emirati special forces off the coast of India. Latifa was then allegedly taken back against her will to the UAE, and since then her whereabouts has essentially remained unknown. Latifa's case came to light after Detained in Dubai, an organisation which works on behalf of people caught up in the UAE's legal system, released a 40-minute video in which Latifa describes how she and her sister were mistreated, imprisoned and abused by the Al Maktoum family. In the video, which was then subsequently published on YouTube, Latifa explains her story of being jailed after trying to free her sister Shamsa, who she says had been held captive for 16 years at the request of their father after she tried to run away to London. After Shams' detention in 2002, Latifa said she wanted to free her older sister. She alleged that at the age of 16, she too attempted to escape the UAE, but was caught at the border, which had led her to being imprisoned and tortured at her father's orders. Latifa ordered this video to be released if her escape attempt failed, and detained Dubai duly did so, yet nobody has heard from her since March the 5th of this year. In May, following a request for internation from Guernica 37, which is a law firm representing the princess, the United Nations Working Group on Enforced or Involuntary Disappearances asked the UAE and India to respond to allegations of Latifa's arbitrary detention and enforced disappearance. As well as this, Human Rights Watch have since called on the UAE authorities to reveal her status. However, the UAE authorities are yet to provide an official comment in regard to this. And another very high-profile case which has occurred since the UPR in December 2017 is the detention and disappearance of the award-winning Emirati human rights activist Ahmed Mansour. Possibly one of the UAE's most well-known human rights activists, Ahmed Mansour has a prominent standing within the human rights community. Over the years, he has worked extensively with international rights organisations to raise awareness to human rights abuses in the UAE, with seats on the advisory boards of the Gulf Centre for Human Rights and Human Rights Watch. In 2015, he won the prestigious Martin Ennals Award for Human Rights Defenders for his work in advocating for basic civil and political rights in the UAE. Last month, Abu Dhabi's Supreme Court sentenced him to 10 years in prison after finding him guilty of using social media to quote-unquote defame the nation. He was also ordered to pay a fine of 1 million dirhams and to be placed on close surveillance for a further 3 years at the end of his sentence. Prior to this, UAE authorities had held Mansour for over a year in an unverified location without charge or access to proper legal counsel. According to Amnesty International, during this period, he was permitted just 2 short, supervised family visits away from his place of detention. In February 2018, in a mission mandated by the Martin Ennals Foundation, Frontline Defenders, and the Gulf Centre for Human Rights, among others, 2 Irish lawyers travelled to the UAE in an attempt to track down Mansour's whereabouts. They approached the Ministry of Interior at the headquarters in Abu Dhabi, which is the authority controlling and running the prisons. The ministry, however, referred the lawyers to the police, who are not responsible for the prisons. The police then advised them to approach the Al Wafra prison, which they did, only to be told Mansour was not being held there. They subsequently left the UAE without seeing him or tracking down his whereabouts. According to local media, Mansour was convicted of quote-unquote insulting the status and prestige of the UAE and its symbols, including its leaders, and of seeking to damage the relationship of the UAE with its neighbours by publishing false reports and information on social media. It appears as though Mansour was convicted in line with the UAE's Federal Law No. 5 on combating cybercrimes. Instituted in 2012, the decree's vaguely worded provisions essentially provide a legal basis to prosecute and jail people who use information technology to, among other things, criticise senior officials, argue for political reforms, or organise unsolicited demonstrations. Since its institution, scores of political dissidents and human rights defenders have been jailed for social media comments. Despite the court decision, however, Mansour's exact whereabouts and conditions of detention remain unknown. Furthermore, while the news of Mansour's conviction was announced in the local media, there is no public record of the trial itself, and so far there's been no official statement from the authorities actually confirming the conviction. Moreover, although it was reported that Mansour was represented by a lawyer, it's still unclear whether this was actually a lawyer of his choosing. On the 12th of June 2018, UN human rights experts urged the UAE to reverse Mansour's conviction, stating that it represents, quote-unquote, an unacceptable attack on freedom of expression and freedom of association, as well as on human rights defenders in the United Arab Emirates as a whole, adding that not only is such a sentence unreasonably severe, but Mr. Mansour should never have been detained in the first place for legitimately exercising the freedoms that all people, including human rights defenders, are entitled to. In light of the above cases, it is imperative that the UAE immediately and unconditionally release Ahmed Mansour. Pending this, however, They must reveal his location of detention and ensure that he is being treated in line with the UN standard minimum rules for the treatment of prisoners. As well as this, immediately reveal the whereabouts of Sheikh Latifah and give guarantees regarding her personal safety and well-being. Accept as many recommendations as possible from the 29th UPR, especially those concerning the ratification of important human rights instruments such as the ICCPR. And we also call on the UAE to implement the recommendations which were accepted from the previous UPR. And we invite all member states to put pressure on the Emirati authorities to do the above. Thank you very much for listening.
Thank you very much, Joe. I'm afraid we're running out of time, but we're happy to take questions outside the room if anyone in the audience wants to reflect on some of the things that have been said. To wrap up quickly, I think from all the speeches that we've heard, we do sense a feeling of disappointment when it comes to the recommendations that have not been accepted by the UAE. But I also want to reflect a little bit on and remind ourselves of what the UPR is about. In the end, the UPR remains a peer review of states by states in which they get to pick and choose which recommendations they want to work on in the next 4 to 5 years. And I would also like to reflect on something that Mr. Dyke has mentioned in his video, is the need to collaborate with the UN mechanisms. And I think that in the current situation that we're facing now in the UAE, with none of us being Emirati, as my colleague Julia has explained, and all human rights defenders being behind bars, that the people using the UN human rights mechanism is the only remedy they have, because at the internal level they have no way to remedy their situation. And if the UAE at least committed to collaborate further with the UN human rights mechanisms, we could get all these people who had Uyghur opinions released. We could get all these people who are disappeared and had the cases pending before the working group on enforced disappearances reappear, or at least that the families are made aware of their fate and whereabouts. Again, it has been mentioned several times by my colleagues. We're also happy to see that the UAE have submitted their 5 years overdue report to the Committee Against Torture, and this will definitely allow civil society to have, let's say, a stronger voice in comparison to the process of the UPR, to bring testimonies of victims to the table and have an independent review by UN experts of the situation of torture that has been brought up many times by my colleagues here. Well, thank you everyone for coming, and we can continue the discussion outside if anyone has questions.